I'm joined today by Andrew Torrez, who's a graduate of Harvard Law School just over the river from us in Cambridge, Massachusetts. He's been practicing law for 21 years and is also the co-host of the Opening Arguments Show, the legal podcast that helps you make sense of the news. Andrew, it's so great to talk to you today. I want to start by talking a little bit about some of the terms that have been ascribed to Supreme Court nominee Neil Gorsuch. And some of these terms include that he is an originalist, that he has a textualist interpretation of the Constitution. You see a lot of these terms as sort of code when it comes to analyzing judicial philosophy, don't you?
Yeah, that's right. So first, David, thank you very much for having me on the show. It's a real honor to be here, and I'm looking forward to it. With respect to originalism and textualism, which is what originalists like to call themselves, now that there is some pushback on originalism, as a bit of a dirty word. I mean, it is my view that originalism is internally incoherent as a judicial philosophy. It is way outside the mainstream, liberal or conservative, as a method of jurisprudence. And it should be disqualifying if you're going to serve on the Supreme Court.
And when we talk about the way in which the term a judicial activist is sort of thrown around, it seems that
Mhm.
on the political spectrum, you have both sides using that term to mean drastically different things. So let's talk a little bit about that. When we step
Sure.
back from the politics a little bit and say, okay, where is the line drawn between a judge interpreting the law and a judge doing activism? Is there some specific definition that we can apply to some of these terms?
Yeah, I think there is. So judicial activism has at its core a real criticism, right? There's a separation of powers based criticism, which is to say that the legislature is supposed to make the laws and the judiciary is supposed to interpret them. And so the phrase judicial activism originally meant when the judiciary took an existing base of law and grafted something completely novel on top of it. Okay, and that's really important because the right wing has really hijacked judicial activism. I mean, in ways that are in some cases laughable, right? And it has now become, if you hear on Fox News the phrase judicial activism, that just means a decision by a judge that reaches a non-conservative outcome. Right. So, for example, it was tossed around in the Kitzmiller versus Dover decision against, which was the battle over intelligent design in Pennsylvania. And the judge was, a George W. Bush appointee and a long-standing conservative, and he predicted in his opinion that the critics were going to call the decision activist. And in fact, the Discovery Institute released a press release after that decision came out, which said this is activist judge rules against us. So it's become kind of a generic slander against judicial opinions that the right doesn't like. But it's my view that that the core that originalism, which we can sort of define and talk about, but that opens the path for the most possible conservative judicial activism. Right? That is for conservative political ideologues to reach the results they want in particular cases.
And it's sort of almost that by definition, if you think about what we mean when we say conservatism, and then when you think about the idea that you are going to apply a document literally that was written hundreds of years ago to life on Earth in, for example, 2017, it's sort of by definition the most conservative possible way that a judge could interpret law, isn't it?
Yeah, so I mean, there are two things that kind of immediately come to mind there. Right? The first is that the Constitution, by and large, is not written like, for example, like speed limit laws, right? Like the speed limit says you can drive 65 miles an hour on I-95. It's a bright line rule. If you're traveling 66, you're violating the law. If you're traveling 65, you're okay, right? Almost nothing in the Constitution is written that way. Most of the Constitution is written with deliberately expansive phrases, right? So, like the Fifth Amendment protects you from the deprivation of life, liberty, or property without due process of law, right? Well, what's liberty? What's a process? How much of it are you due? all of those are things that it's very, very clear the founding fathers intended the judiciary to expand and explain what those terms meant. So taking an overly narrow view is inconsistent with the text of the Constitution, and it's also inconsistent with, as far as we can tell, the writings of the founders themselves. Right? Like, we have the Federalist Papers. We know the people who wrote the Constitution, what they intended for the judiciary to do, and they did not intend for the judiciary to fetishize either the text of the Constitution or the writings of the founding fathers. Right? So if you want to look back to what the founding fathers thought, they didn't think, hey, put us on a pedestal and never change stuff. They thought, we're giving you a framework that contains expansive terms, and we want that to fill out over time. And there are a number of, sort of really clear examples of this where originalism just gets you, absurd results.
Can you give us a couple of those examples? I think that'd be interesting.
Yeah, sure. So, for example, the Eighth Amendment protects individuals against cruel and unusual punishment. Okay, so what is cruel and unusual punishment? There have been two different originalist takes on that phrase. Okay, and one is to say cruel and unusual punishment is anything that the founding fathers thought was cruel and unusual punishment in 1787. The problem with that is that's almost nothing, right? Like in 1787, it was perfectly fine to flog people for public hangings, for pillorying people in the stocks, for breaking people on the wheel. Like the last law prohibiting breaking on the wheel, that is, taking a paddle wheel and kind of waterboarding somebody on a certain, it's torture, right? And the last law to prohibit that was passed in the 20th century, I think in Rhode Island, right? So if you go by that view, then the Eighth Amendment literally means nothing. It does not prohibit torture. It means if, Alabama tomorrow decided we were going to put blasphemers in the stocks, then they would not have a right under the Eighth Amendment. And that's just, that should strike you as absurd.
And to jump in just for 1 second, Andrew, so what
ahead.
You're basically saying is, if you're interpreting the Constitution in sort of this originalist, textualist way, based on what the founders meant at the time that it was written, you're talking about, hey, at the time, these are punishments that would have been allowed. Thus, a textualist interpretation would say they'd be allowed today.
Yeah, and if I know you have lawmakers who listen to your show. If anybody on the Senate Judiciary is listening to the show, I would love for them to ask Neil Gorsuch what punishment specifically he thinks the Eighth Amendment forbids, because there is no consistent originalist, textualist way to say that the Eighth Amendment forbids anything. Other than, sort of bizarre hypothetical. And I would just ask follow-up questions. Say, does it prohibit public hangings? Does it prohibit whipping? Does it prohibit pillorying? Does it prohibit the stocks? And there's no consistent way to answer that question. I can tell you how Antonin Scalia answered it. Antonin Scalia said, no, it doesn't. Now, mind you, he didn't say that until after he'd been confirmed by the Senate and was sitting on the Supreme Court. But that's the only consistent view you can have. If you track that, and in fact, Scalia wrote an opinion in which he parsed out, in which he said that life imprisonment without parole for the crime of passing a bad check was not a disproportionate punishment prohibited by the Eighth Amendment. And his analysis was, and I'm not making this up, right? You can look up the opinion that it prohibits cruel and unusual punishment. And while mandatory minimum sentences for minor crimes may indeed be cruel, they are not unusual in the constitutional sense. So in fact, I think if you Google unusual in the constitutional sense, you'll get the opinion. And it's just, it's just preposterous, but that's where that leads you. And, it used to be the case, right? In 1987, the Democrats mounted a successful opposition to Robert Bork on the Supreme Court. There was no question that Bork was intelligent. There was no question he was serving with some distinction as a judge on the District of Columbia Court of Appeals, on the United States Circuit Court for the D.C. Circuit, which is a feeder circuit to the Supreme Court. Clarence Thomas was on that court. Antonin Scalia was on that court. So there was no question Bork was a smart guy. But the hearings focused on the fact that he had an ideology that was way outside the mainstream of American jurisprudence, and it was based on his ideology that he was rejected, and that Reagan was sort of forced to come back. Eventually, there was a candidate in the middle who had some kind of bizarre personal struggles. But eventually he came back with Anthony Kennedy, right, who was a moderate. And the Democrats in the Senate said this seat, needs to go to a moderate, can't go to somebody with an extremist view of jurisprudence. And I'd like to see the Democrats do that again.
Andrew, in the limited time we have left, I'd love to hear your
Sorry.
thoughts on this constant sort of meme that shows up in confirmation hearings for Supreme Court justices, which are questions of sort of differing specificity about abortion and Roe v. Wade. And typically the way it goes is individuals on the confirmation committee will ask some kind of question about the nominee's views on abortion or Roe v. Wade, and you typically get some type of answer where it's this generally a formatted answer of these are issues that may come before the court, and it would be improper for me to prejudge before examining the merits, et cetera, et cetera, et cetera. How did this become such a common thing, and what's the sort of point of that at every confirmation hearing?
Sure. So it's important to remember Roe v. Wade was a 7-2 decision, right? Like this was not a particularly, I don't want to say it wasn't controversial. It was. It was controversial politically, but not judicially, because the Supreme Court had built up a body of jurisprudence concerning what was considered the right to privacy. And privacy is sort of a weird word for it. Because of the colloquial meanings that it has. But essentially, those were decisions recognizing the key right to bodily autonomy and to make decisions about reproduction and childbirth and marriage. And so you had a line of decisions, starting with Griswold v. Connecticut, that said states can't ban contraceptives, right? You had Loving versus Virginia. States can't outlaw interracial marriage. And so those decisions were at the core of what the court called the right to privacy, which inheres in the 14th Amendment and what was described in Roe v. Wade as sort of the penumbra of the Bill of Rights is today considered a part of the due process clause of the 14th Amendment. And so if you have the mainstream view of jurisprudence, I stress this, this is the view that liberal judges have it, conservative judges have it, moderate judges have it. As long as you're not an originalist, if you follow sort of the mainstream idea that precedent matters, then you recognize that there's a longstanding history of the right to privacy. And then the Roe decision is perfectly consistent with that, right? You could address it, sort of contours at the edges like the court did, subsequently in the Planned Parenthood versus Casey case about 20 years later. But you can't say Roe v. Wade was wrongly decided. The only way to say that is to have kind of a radical originalist view that says we can bypass 220 years of jurisprudence and go back to the founding of the country and say, no, we're going to overturn Roe v. Wade. So the non-answer has come about since the Bork hearings as a way for conservative judicial activists who want to reach that end goal of overturning Roe v. Wade, but they don't want to concede in their hearing that that's their goal. They don't want to answer squarely the question of whether there's a right to privacy in the Constitution, because under their philosophy, there isn't. But under the judicial philosophy that, again, I want to stress, like 95% of lawyers, or wherever you are on the political side of the spectrum, adhere to kind of that mainstream view that precedent matters. So that's where that comes from.
Very, very informative. That explains a lot about why we hear that so often. I want to encourage everybody to check out the Opening Arguments show, the legal podcast that is co-hosted by our guest, Andrew Torrez. Excellent program. And I really appreciate you being on with us today, Andrew.
David, thank you very much for having me on. It's been a blast.